I'm Nicole. I'm the office manager here at the Fischetti Law Group. We are here right in Florida on Boynton and Hagen down the street. We specialize in helping people navigate complex legal issues, including estate planning, personal injury, and insurance litigation. Our firm has been dedicated to serving the community for many years, and our main goal is to help our clients protect what matters most to them, whether it's their health, their home, or their legacies. I'd like to introduce my two wonderful attorneys. First, I have Mr. Michael Fischetti. He's the managing partner here at the Fischetti Law Group. Michael has extensive experience in Florida law and a passion for helping his clients achieve the best outcomes in challenging situations. He is known for his hands-on approach, which is him coming into the office at 4:30 in the morning, Monday through Sunday, really, and has a deep commitment to client service, whether it's advocating in court, offering legal guidance and estate planning. Michael brings both experience and dedication to everything he does. Next, I have our associate attorney, Ms. Cheyenne Pearson. She is a key member of our estate planning team. Cheyenne is dedicated to ensuring that each client's unique needs are met with personalized solutions. Her expertise in estate planning helps families secure their wealth with confidence, providing guidance on everything from wills to trusts and healthcare directives and deeds. Cheyenne's compassionate approach makes her an invaluable resource for our clients, especially when navigating sensitive topics. At the Fischetti Law Group, we understand that estate planning can sometimes seem a little overwhelming, but today's goal is to really simplify these concepts and showing you just how the key steps can make a huge difference into planning your life and for you and your loved ones. By the end of today's seminar, you'll have a better understanding of important tools like living wills, healthcare proxies, quitclaim deeds, ladybird deeds, revocable trusts, and last will and testaments. At the end, we'll have a little bit of a Q&A, but I am going to pass it over to Mike and Cheyenne to go ahead and explain how we're going to run things, but I'm going to pass it over to them.
First of all, thank you guys all for coming out. Ms. Harris, thank you so much for welcoming us here and allowing us to come to speak to everybody. We will try to overly simplify everything and be here to answer all of your questions, and at the same time not go too long, boring, and droning on, because it actually has a really pretty nice night out. As Ms. Nicole said, my name is Michael Fischetti. I am the founding and managing partner of the Fischetti Law Group. I have been an attorney since 2004. I have litigated in excess of 15,000 cases. I have handled thousands of clients for estate planning, and I can tell you the one thing that I'm most proud to say is that the idea when our firm founded was to be client-centric. We are in the customer service business, and as we've grown and expanded to 28 employees now, we still have that same focus. So whether it's a doctor that hires me to file 8,000 lawsuits against an insurance company, or somebody that comes in and just has a really innocent question about a living will, what is it, what does it do, we will always stop whatever we're doing and focus on that. And one of the leading reasons, or one of the main players, are my staff. They're absolutely fantastic. You got to meet Ms. Nicole, so Ms. Nicole, thank you for the introduction, and thank you for working with Ms. Harris in setting this all up. And to the right of me, this is Ms. Pearson. Cheyenne came out with us 3 years ago and has taken the world by storm and just thrown herself into everything that is asked, from appearing in front of court, which as somebody who's a young attorney, it can be overwhelming. She does it with poise and grace, and let me tell you, when it comes to the estate planning, she's always available, always ready to answer questions. So the whole purpose is to kind of quickly, simply go through some of the main things that you need to know, and terms you need to know about estate planning, so it doesn't seem so foreign. We tell this to clients all the time. It's kind of an uncomfortable topic. Nobody necessarily wants to be like, what happens when I pass? But the one commonality of every client that we deal with, when they have everything situated and they leave, they always say it's a weight off of their shoulders. It's something that they had some housekeeping to tidy up. They got it done. They feel better about it. But always remember, everything can always be revised and changed. And our goal here today is to kind of give you an insight into it. But everybody's estate plan is unique into themselves, because everybody's situation is different. So I'm going to have Ms. Pearson kind of lead us off on some topics. I'll come up on the back end, and then we'll get a little bit of Q&A. So I give you Ms. Pearson.
All right, so thank you, Michael. That was a great introduction. So we'll go ahead and get started. So I want to talk a little bit about why estate planning is important. I know sometimes one of the biggest things that I hear on the phone when I'm speaking with clients is, oh, I don't have a lot, so I don't really think I need this or I need that. But there's a lot of components that go into estate planning that are really important that cover things besides just assets or what people may consider an estate. It can cover things from your healthcare, making medical decisions. It can also, and mostly everybody does own a home or they have some type of structure that they're living in that they may want to pass down. So that can be kind of constructed in a way without doing a trust, but with some other estate planning tools that may be more fitting to your needs. Which is why, again, every estate plan is going to look different for everybody because people have different goals. But some of the main reasons why estate planning is important is protecting your assets. You all have worked a long time, you've worked hard, you've put a lot of effort into where you are now, and you want to make sure that that is protected in whichever way you can. One of the biggest things as well is getting ahead of mental capacity. It's very, very important to make sure that these documents are in place because once mental capacity becomes an issue, it's hard to go ahead and move forward with signing legal documents. And so that's going to be a problem when things need to get moved around or you want to assign power over to somebody when legally, if mental capacity is a problem, we won't be able to do so. Next is safeguarding your loved ones against legal battles. While everybody likes to think that their family is going to handle their passing away and their estate amicably, that is not the case, which unfortunately is why the law has a whole department set up to handle these issues, which is known as probate. So making sure that everything is done in a properly executed, tailored, very clear estate package is going to make sure that everything transitions smoothly. Next, the important thing with choosing estate documents is being able to choose who you want to take this on, whether it's a spouse, whether it's an adult child, whether it's a best friend, a sibling, because it's going to be important that although you may want to name somebody that is great, you get along with, but important decisions have to be made here, and so you want to choose somebody that you trust and somebody that you know is kind of going to make the right decisions regarding your estate. And then next, again, determining healthcare decisions. That's a really big part of estate planning that sometimes gets overlooked. And so we're going to go into two very important documents that cover that. And then lastly is just passing on your wealth. Most of you probably have children or grandchildren, and if you don't, maybe you have a charity or something that's very close to your heart that you'd like to make sure that gets that you see your assets get distributed to. So our first document that we're going to be speaking about is a living will. So a living will is a document that is effective upon signing while you are alive that allows you to lay out the type of medical care that you want or that you don't want in the event that you were unable to do so for yourself, okay? You can direct in this document two very important things. Whether in an end-of-life situation you would like to be kept alive artificially on tubes, ventilations, that sort of thing, or if you would like to go ahead and pass naturally. Pretty much, this takes the burden off of your family having to decide what to do because they're not sure. And again, this decision is really made, like I said, in an end-of-life situation, when you're in a vegetative state. If you are comatose with little to no brain activity, any medical procedures at this point would be considered that it's not going to help at this point. And so, what option is left? This paperwork is here to lay out what your specific wishes are. And the biggest thing is that it's legally binding. So although your family may have different wants and wishes for you at that state in your life, you've kind of already laid it out, and it's going to be responsible for whoever you designate to make sure that those wishes are carried out, and providers and doctors have to legally honor that as well. And our next document is going to be, and then we have a real world hypothetical. So John, age 75, had a stroke and was in a coma. His family disagreed on whether to continue life support, and because he had no living will, the court became involved, causing delays and emotional stress. Okay, so this document would be able to navigate and be the front runner of the decision that's being made regarding his life. Okay. And then our next document is called a healthcare proxy or medical power of attorney. So a lot of people get these confused because they do fall under a realm of healthcare directives, but these are two very different documents, okay? And a healthcare proxy is, again, a legal document that is effective upon signing and while you are alive, that allows you to designate a trusted person as your agent or your healthcare surrogate to carry out wishes or on medical decisions for you if you're unable to. But the way that this differs from the previous one that I just spoke about is this kind of covers things that happen kind of more frequently. So let's just say you have a surgery and you're kind of a little groggy coming out of surgery, and the doctor needs to administer medication. In this instance, you know, if there are two options, they're going to look to the healthcare agent to say, hey, you know, these are the effects of this one, these are the effects of this one, which one would you like to choose? Once you become a lot more stable in your condition, your wants and wishes are still followed. So whoever your agent is, they don't get to override your decisions once you are now able to talk again and you understand kind of what's going on. Again, I use this kind of similar to if you're ever in a car accident or something and they just need to get in touch with somebody because you're unconscious. This would also be one of those situations where they would look to if you have designated an agent. Again, it takes without having this document and without, you know, if they're not able to reach any family members or anything, the decision pretty much gets placed in the hands of the state or the medical providers that you're treating with. And again, like I said, it's active upon signing and while you are alive, so it does die at death. And then also you can designate multiple agents in case they're not able to get in touch with the first agent that you've picked. So typically you see people choose a spouse and then maybe an adult child. And then our real world hypothetical here, Mary, 82, lost consciousness and her children were divided on treatment. The hospital had to rely on statutory law to appoint her eldest son, whom she did not trust with medical decisions. So sometimes that also delays what procedures need to be done as well because there's no clear paperwork. Okay. Our next document is a durable power of attorney. And again, this is a legal document that is effective upon signing and it gives somebody else the authority to act on your behalf, okay? So this one is usually regarding financial or legal decisions, whereas the previous one is only related to healthcare and medical decisions, okay? But a power of attorney can be broad, it can be specific, so it can also cover a range of things. It can allow somebody to sign contracts on your behalf. If you own a business, they're able to kind of help run that. Banking, you know, being able to sign and manage your financial affairs, that's again the biggest one that we see. They can be temporary, so you may only need a power of attorney for somebody to do something for you in in this one instance, and you don't want to have them have it forever. You simply revoke it, and if you don't revoke it, then it is permanent. But again, an agent should only be acting at your direction, so it's not just signing over your life and they're able to take this paperwork and do whatever they want with it and start messing with your affairs. There are legal repercussions if they are found out to be doing things that were not at your direction and things that they shouldn't have been. The great thing about a power of attorney is that it is effective in the event of mental incapacity. But you do want to make sure that it has durable language in there, which is what sometimes people will call asking for a durable power of attorney. If it's not durable and you only get a regular power of attorney, what happens is that with a regular power of attorney, the moment you become mentally incapacitated, it's no longer good and it's ineffective. So you want a durable power of attorney if you want somebody to still be able to manage your affairs on your behalf if you're unable to do so because of mental incapacity. Okay. And then you can determine the scope. Again, like I said, they could be very broad or very limited in powers. And the biggest misconception, and that I have to explain to people is that under Florida law, spouses do not automatically have financial or medical powers. So this means that although you may be married, and if you need to go and handle a business, handle some affairs in your bank, and it is not a joint account, let's just say your spouse is only an authorized user, or you're sending them to do something for you, a financial institution is not going to allow them to do so. That is probably the number one reason we get people in the firm asking about a power of attorney, because they absolutely, under no circumstances, banks, whether it's a checking savings account, a money market account, a stock account, if you're not listed on there as a joint owner, they will not give you access. A lot of the times they won't even speak to you about it. And same with medical decisions as well. While your spouse is the person that they will look to if there is no paperwork in place, what will happen is if you have an adult child and they try to challenge your spouse, it becomes a problem. Not saying that the spouse eventually won't become the one to have the ultimate and final decision, but it may delay things in the process, and the hospital or doctor's office or wherever you may be at that is treating, they may have to take it up with their legal department and higher powers before a decision actually gets made. Okay. And so we have a couple real world hypotheticals here. You can kind of read through here, but I'll just kind of touch on this one in the middle because it's a little bit different. So it's selling a property for an elderly parent. John, 85, wants to downsize and sell his home, but due to mobility issues, he cannot attend the closing. So he uses the power of attorney to authorize his son to handle the entire sale process, including signing the necessary paperwork with the title company. So that's just one example of when a power of attorney can be useful. Okay. And then the last slide that I'm going to touch on here is going to be a quitclaim deed and a ladybird deed. Okay, so again, two very different documents, and they do two very different things. Okay. So a quitclaim deed is a legal document to transfer ownership of a property from one person to another quickly and easily. This is also used if you want to add somebody onto a deed, or if you'd like to take somebody off of a deed. This is typically used between family members because it does not guarantee that the property is free and clear of any legal issues. So ideally, while we are not real estate attorneys, we do kind of deal with real estate when we're dealing with trust and other things when it's dealing with a home. So if you're ever dealing with somebody and they're trying to do a quitclaim deed and it's not a family member, somebody that you know and that you trust, we definitely don't recommend doing that. Again, like I said, it's mostly used to add a child or spouse on or take them off. But this is the deed that you would use to transfer your home if you were opening a revocable living trust. It's a smooth and easy transaction. The only thing that you'd want to keep in mind is that if there is a mortgage on the home, if you're doing a quitclaim deed, you will be subject to a doc stamp tax. However, that does not apply if you're putting the home into a trust, because technically under a trust, you still retain ownership. Next is the ladybird deed, and it's also known, as an enhanced life estate deed. Okay, so those names, they mean exactly the same thing. And this is a special type of deed that allows you to transfer property automatically upon your death. Okay, so this deed lets you keep full control of your home, of your property. You can rent it out, you can sell it, you can take out another mortgage without needing the beneficiary's consent to do so. Okay, so the deed will actually lay out that you yourself are giving the home back to yourself in a life estate, so you will own it for your life. Able to do with no restrictions, you're able to do whatever you want with it, but it will also say that as a remainder interest, the house is to pass to whoever you've named, most likely adult child. And from there, it still, again, allows you to retain full control. This deed can be revoked, you can change it. So if you don't want it to pass to your child, or you want it to pass to another child, you're able to do another deed to do so. This one will avoid probate. So this deed is typically an option that we present to our clients who may not be looking for a trust or who may not need a trust. And Michael will touch a little bit on trust in just a second, but you're gonna see it's a very complex and kind of intense document. It's kind of like the final step, I always say, in estate planning. So sometimes depending on what your wants and your wishes are, it's just not always necessary. And this is a good and quick, easy way to also get the same effect of passing your home to one of your loved ones. And it avoids probate. So again, same thing as a trust, as Michael will touch on in just a few seconds, is that it does allow you to avoid probate. And the next slide here. And then our last hypothetical for this one is going to be Ann, 80, transferred her home to her son using a quitclaim deed to avoid probate. Later, she wanted to sell the home and move into assisted living, but her son's consent was required, leading to complications. So again, with the quitclaim deed, she transferred that ownership immediately upon signing to her son, meaning now it's joint ownership between her and the son, and she cannot do anything with that home if her son does not also sign as well. 2 signatures will always be needed to do anything with that property. Versus if it was a ladybird deed, if she still, while the son would still be listed on the deed and in the records, he does not have any type of control, any type of interest until that person passed away.
Are there doc stamps on a ladybird?
If there is a mortgage on the house, there can be, or actually no, I don't think so, because you're still retaining interest in yourself. So no, if you do a ladybird deed, you're not transferring interest to another person yet, because you're still alive, so you still retain it. So no, typically there is no doc stamp associated with the ladybird.
Does Florida recognize living trust?
Yes, they do. Yep.
Is it inherent or has to be written?
Excuse me?
Is it inherent in law or does it have to be written?
The trust has to be written. Yes, we don't. Everything has to be written in
Or a
Florida.
legacy agreement?
Yeah. Excuse me?
It's also called legacy agreement.
The legacy agreement.
Spouse can stay within the house until she passes away.
Oh, okay. So that I think has to do a little bit more with the homestead.
Yeah.
There are homestead protections that are in place, correct? And again, while we can help facilitate the transfer of things, when you're starting to deal with homestead laws and the acts, and then also again a little bit more in depth with the taxes associated, we definitely would recommend still speaking with a Florida attorney that does real estate law or property law, because they're going to be a lot more versed in it than we are. But yes, homestead protections do come into play when you're trying to decide exactly who's getting a home, and I think that has to do with your spouse and if there's minor children involved. Okay.
All right. Thank you, Cheyenne. I have been lucky enough over the past 20 or so years to have 9 attorneys come up under me, and they've all either moved to different states or gone on to open up their own law firms, and they're fantastic. But what I can say about Cheyenne is she has thrown herself into this like I've never seen. And what we're here doing today is really, we're just scratching the surface. But for estate planning, it can either be as straightforward and simple as you want it to be, or it can get incredibly, incredibly complex. You can have a trust inside of a trust inside of a trust. But what we're really trying to do is to kind of spark some conversation and start telling you a little bit how you can avoid problems for your family down the road. When you do set up an estate plan, it's really one of the most selfless things you can do because you're preventing any potential conflict down the road. So I'm going to talk a little bit about wills and a little bit about trust. But before I do that, are there any people that are here that are snowbirds? Okay. Everybody else is full-time Florida resident? Okay. So for our individual here, who's a snowbird, it's always important to know that out-of-state wills will not necessarily apply in Florida automatically. So if you have an out-of-state will, you're going to want to have a mirror of that in Florida. So I'm going to start talking about wills, kind of the purposes and intent, and then we'll get on to a trust. Okay? The will is designed to have your wishes presented and put forth after your passing. Now, normally when we talk about a bigger spectrum of people, we'll always talk about who's going to take care of your children, who's going to watch out over them. But I think that here, from my understanding and the brief conversation I've had with everybody, most of you, for the most part, have adult children. but it very much can come into play if you need to name an executor to watch a disabled older child. Some of you may still, have a child that fits that parameter, and a will be able to allow you to do that. Now, just having a will does not necessarily avoid probate. That's something that some people are it's a common misunderstanding. They think if I have a will, it's going to avoid probate. Actually, in the state of Florida, if you follow all the statutes to the T, you have to file your will upon passing with the court. Now, that doesn't mean that that will is up to be challenged. All it means is a judge needs to look at it and see on its face that it's valid, and that they need to put anybody on notice who needs to be put on notice. So before we go any further, I just want to be very, very clear that although a will is incredibly important and can really be the cornerstone of everything, it does not avoid probate. Okay? For the most part, when we're talking about wills and the need for wills, it's going to be about getting your wishes for your passing and property. So you're going to want to put in your will who is going to get those properties, and you're going to need to establish who is going to be your executor. Now, a lot of people will have family members, but it doesn't necessarily have to be a family member. You could have multiple executors of your will. Now, the one thing that we always tell people is it's probably not a good idea to have it be an even number. Because if you have two people named as an executor and they don't see eye to eye on things, it's going to create deadlock. So if you have 3 children and you don't want to leave anybody out, feel free to name all 3 executors, so at least that can be a decision. That's a majority rules type decision. The main purpose of the will is that it is only, not the main purpose. It will is effective upon the passing. Cheyenne talked a little bit about those things that are effective upon signing. Your will only control after you pass. In the state of Florida, if you are married, it's always going to be assumed, if you are married, and nothing is put forth in your will otherwise, that all of your assets will go to your spouse. The 2 things that if you are married, and you have beneficiaries that may inherit things in the future, I want you to walk away tonight knowing that you need to know who's a beneficiary on any annuities or life insurance policies. It seems like common sense that you would always name a beneficiary, but we have seen quite often with a life insurance policy or an annuity that the beneficiary is not named. That is in itself can be a problem even if you have a will. So anybody who has life insurance, anybody who has investment accounts, please take the time in the next couple days to make sure that your beneficiaries are named. Now, if all you had was one retirement account and you named one beneficiary, and that's all the assets that you had, you could avoid doing a will. So that's kind of a piece of advice, number 1. Number 2, that you always want to make sure is that on all of your bank accounts, you have what's called payable on death. To name someone who will have access to your bank account upon your passing. If you name somebody to that position for payable on death, that doesn't necessarily mean they have any access to your bank account while you're alive. They can't even find out the balance. But having someone as a POD, payable on death, on your bank accounts can be critical when there are expenses that are needed for, say, a funeral. Because even if something's not being contested, you go into a bank with your properly notarized will and a death certificate, the bank's going to say, for the most part, thank you, we got to send it to legal. And if anybody has been dealing with banks lately, they don't move very fast. So I promise you they move much, much, much slower when they have to send it to legal. And that could cause a real economic hardship when trying to pay for the cost of a funeral. Unfortunately, over the last few years, I've had several family members pass, and I know what funeral prices are, and it's not like you're going to go into your couch and find some change to get that, to pay for that. One of the requirements of a personal representative or an executor is that they have to be a Florida resident. So it makes it difficult if you're down here by yourself and you don't have family or friends here in the state of Florida. It gets a little more complicated, but it's something that we can always take care of. Cheyenne talked a little bit earlier about capacity, mental capacity, and incapacity. There are some times when I wake up in the morning on no sleep, I feel like I have no mental capacity. But it's a much different standard when it comes to signing legal documents. For the most part, when we meet with people, we can tell very, very quickly whether they're going to meet that standard just based on a common sense approach. But if there is a question about mental capacity at the time of the signing of the will, it can cause problems down the road, and it is one of the main reasons why someone can challenge a will. So one way that we always kind of get around that is we get a simple observation, a recommendation and letter signed by most of the times a general care doctor. Okay? So if somebody comes in and we're a little nervous about it, we'll get them signed, a letter signed by a doctor that says that they're of sound mental capacity. Because again, that's one of the biggest things that they can challenge on, and one of the most likely successful challenges. Courts loathe to discontinue someone's wishes. Courts generally are independent arbitrators of a will. They're not going to hop in and say what they think is more fair or they think should be done. They can't. There are volumes of case law that have come out that shows that the judge has to be absolutely neutral and rule only on whether the will is improper on its face or there's mental capacity problems there. When you do a will, most people think that that will is something that's being chiseled in stone. That's why a lot of people will put it off, because they want to make sure that that decision is ironclad and correct. A will can be changed at any time, and it's actually very, very simple. There's a clause that's placed in the will that basically disavows any earlier wills. So we've seen in our experience where people will come in and they're torn between who is the executor. A lot of times it's the difference between children. You know, do I want one child or the other? And what we always like to tell them is, as circumstances change and as life changes, you can easily change your will. And not just as to who the executor is. You can change who you want to get your assets.
Just a question to clarify, maybe I misheard. Did you say that the executor of the will must be a Florida resident?
If they're not a relative.
Correct.
Only if they're not a relative. If it's a child, an adult child, a cousin, a niece, a nephew, they don't have to reside in Florida. But if it's your neighbor or a best friend, somebody that you met at the post office, then yes, they are going to have to reside here in Florida.
Thank you for clarifying. Okay, next slide. Okay, we try to throw some of these real world hypotheticals out there, not to give you just a standard, but kind of start the thinking process to go through. Here's one where James, 85, died intestate, which is without a will. His assets were distributed according to Florida's intestacy laws, which conflicted with his wishes. When you look at how each state does the distribution of funds, you're going to need a whiteboard and a roadmap of how it goes down, because it goes down, then it goes up, and then it goes sideways. And if anybody's really, really, really interested, I'll be happy to stay back and kind of show you how that roadmap goes. Either way, unless you're very, very lucky and Florida law hits the center of a dartboard, the assets are probably not going to the people you want them to go to most. Remember, also too, in your will, it doesn't have to go in a chronological manner. You don't have to leave your assets to your children in the hopes that your grandchildren are going to get them. You can not leave any assets to your children and leave them only specifically to your grandchildren. There's obviously issues if they're minor grandchildren, but that's kind of what we talk a little bit about in the trust. The purpose of a will, again, is to make sure that all of your wishes, whether they're monetary, property, financial, or just what you want to have done with your remains, are made very, very clear and spelled out and cannot be challenged just because someone might have a different opinion upon your passing. Okay. All right, there are two types of trusts. There are a revocable trust and an irrevocable trust. And then we can get into all the subcategories that go with it. Important thing to know, irrevocable trust whoever you name as trustee, and whatever assets you put in there are there for good. Meaning, you go, I want an irrevocable trust, and I want my son or daughter to be the trustee, and you drop your bank account, your house, your vehicles, all of that there, and you get in a fight over Christmas, and you say, I don't want you to have anything. Yeah, now we've got some legal issues that we're gonna have to deal with. So for the most part, we deal with revocable trusts. A revocable trust is established so that you can make changes as life goes on. Those are those items that you're gonna put in the trust. Those are who's going to be the trustee and the person making the decisions. And when it's a revocable trust, while you're still here, you are in the driver's seat. You are the trustee. So we always like to use the example of buckets. So there's a bucket for this and a bucket for that. And when you have a trust, that's your main big bucket that you're gonna put assets into. Well, you're the one that's driving the dump truck with all the assets in the back. You're making the decisions which way they go. It seems foreign a lot of time, but for me, everything I own is in a trust. My daily life has not changed one bit. My house, my car, my bank accounts, nothing changes. Use the same ATM, write the same checks, have to pay the same insurance rates, which always are going up and up, as I would if I was an individual. But one of the main benefits of a trust is it's going to help you avoid probate. Okay? You're not going to have to file your trust documents with the court. Okay? And you're going to have asset protection to a point with a revocable trust. But it is not complete asset protection. And for most people, that's fine. Most people that don't own businesses really don't have to worry about that. And if they do own businesses and they're properly incorporated, they're gonna have those incorporation protections, okay? For most people that own their home here, Florida, if you don't know, has a very robust Homestead Protection Act, which is why you always see celebrities that get in trouble, sprint down here to buy houses because an individual can't have their house sold, but for 3 circumstances: failure to pay your mortgage, failure to pay your taxes, and a mechanic's lien. I don't know what plumber was around when that law was introduced, but they made sure that if you don't pay your plumbing bill and they sue you and win, they can force your house at sale. But no, really, truly, Florida has some of the strongest homestead protections in the country.
What is the difference between the Ladybird deed and the living trust? Because both said they avoid probate.
A ladybird deed is a singular document with a singular purpose that is much less intense. Where a trust is going to encompass everything, that ladybird deed is just for that singular piece of property that you want to pass on. Where a trust could include your bank accounts, your cars, your house, could include where your life insurance will go. You know, you can make your trust the beneficiary of your life insurance policy. And when we kind of get into trust, like Cheyenne had said, it's kind of the last stop because there is a little bit more planning that needs to go into it because you don't have to put everything you have in a trust. So then it comes down to, what do I put in the trust? And that, quite frankly, is all dependent on what your individual situation is. You know, what your purpose and effect is. So that's why we always say when we get into trust, it's always a good idea to sit down with an attorney as opposed to, you know, a will for the most part. We don't recommend it, but you can kind of maneuver your way through. But with trust, I certainly do not recommend it.
Cheyenne, can you explain payable upon death again, please?
Yeah, absolutely. So a payable on death or beneficiary form is what you would use with any of your money accounts. So a checking account, a saving account, if you have any stocks, anything that is held liquid, you can call up that institution, ask for a payable on death form or beneficiary form, and typically it's a 1-page document. Sometimes you can walk right in and ask for it. Sometimes they may be able to handle it over the phone for you, and you would just list who it is that you would like to be your beneficiary. And again, I always caution my clients when it comes to this, depending on what your distribution is going to be. Because if you have 3 adult children and you want everything to be split 50-50, and you're only naming one of the children on there as the beneficiary or the payable on death, legally, they have no obligation to split that money with the other two children, okay? A payable on death or a beneficiary form is always going to be the number one even if your will designates something else for your distributions. So if you do have an adult child that you really do trust and believe that they'll follow your wishes, by all means, please name them on there. But this is where a trust could also be a good asset, because if you have an existing trust, what you would do is list your living trust as the beneficiary. That way, whoever you've named as a trustee now is held to a legal standard when they go and collect that money, because now they have to make sure that the distributions get split in thirds, okay? So that's kind of where trust would.
And just a quick follow-up, remember, if you have something like a life insurance policy, you can name multiple beneficiaries and you can determine how that is distributed. But really, with the critical thing on a payable of death is really on something that someone needs instant access to, like a bank account. Because they can walk into the bank, show their license, show the death certificate, and then the bank can't say no, they have to follow those. But if you're looking kind of as a distribution of things, you know, the beneficiary route on those documents, you're just gonna have to say who the beneficiaries are and how it's divided. But again, there's a lot more maneuverability when you start talking about trust, setting it up.
Does the person bring the form to the bank, or the bank keeps it in their?
The bank will have them fill out the form, they will keep a copy. So I'm just gonna use, for example, if you bank at Wells Fargo, that's gonna be uploaded into their system and designated as a payable on death. Again, one of the points that Cheyenne did touch on before that's really important, if you have another signer on the account, okay, then maybe your son is a signer, does not mean that they automatically are the payable on death. So they may be able to sign checks now. When you pass, all of a sudden they find themselves locked out.
Yeah.
And it's one of those things, really, it's such a powerful tool that I don't understand why banks and other financial institutions don't push that knowledge out further.
Is beneficiary, I've got beneficiary for all my accounts, got a beneficiary for all my accounts. Do I still need a POD?
No, it's the same thing.
It's one and the
It's
same.
interchangeable.
Oh.
Yep, they're interchangeable. So a payable on death or a beneficiary form, they're the same. It just depends on what term the institution would
Gotcha.
use at the time.
Can you put multiple, can you deed on a ladybird deed, can you deed to more than one person?
Yes, you can. Absolutely. So I just did one, and she had 2 adult children, and yep, we named both of them on there, no problem. And so something like that would also be good. She really only had her home. That was her only big asset. And so when we went kind of through everything, I realized that trust maybe wasn't what she needed. So I suggested, you know, making sure all the payable on deaths and beneficiary forms were filled out on her accounts. We did the ladybird deed, and she was able, and then we did a will, and that was able to kind of cover all of her assets there.
You mentioned the ladybird deed. If you still have a mortgage on your home and you pass, now the ladybird is all set up, how much does this stamp cost if you still have the mortgage? How is that?
So with the ladybird deed, you will not have to pay a stamp tax when you go to record the deed at that time, because with the ladybird deed, you're retaining interest in yourself still. You're just giving yourself a life estate, so it's really not changing any type of ownership. Now, if you're worried about like what happens to the mortgage when you pass away, again, something like that's kind of going to be determined with what your remainder, who you've given the home to, what they're going to decide to do with it. They're going to keep the home. They may have to set up how they're going to start paying off the mortgage. They may be able to use money from the estate to do a full payment and pay it off. They may sell the home, in which case, again, the sale from the home, they'd have to take money out and still pay off that mortgage. But
And if you are going to record that ladybird deed, the cost is like $38. Like,
yeah, $30 to $50 in Palm Beach County. Same with Broward for Miami-Dade as well. So. But I think we were pretty much, I think we kind of got through the trust, and I think that was really our last slide. So if we can kind of go ahead and start getting into the question and answer portion, or if there's anything more that you'd like us to touch on, we'd be happy to do so.
An historical power of attorney, is there a way you can set it up to where it doesn't take effect until you become mentally incapacitated?
So that is what's known as a springing power of attorney, and Florida actually revoked that in 2011, which I had to do a little research on because the way I was taught, even with power of attorneys in law school, was you had springing power of attorneys, you had durable power of attorneys, but Florida, no, that under their law, they changed that in 2011. You either have a power of attorney that is active again immediately upon signing, but once incapacity is gone, it's no longer good, or you have a durable power of attorney. So the springing one in the state of Florida, it doesn't work. It maybe in another state, but again, that's governed by state laws.
If you have a revocable living trust, do you need a will?
Yes. And I always, no, you can. Sorry, I really love estate planning. So with, yes, because we have people that call in and are wanting a trust, and so I kind of have to stop them for a second because I'm like, okay, what are you trying to do? What's your end goal? Why do you need this trust? And then I ask them, do they have any other estate documents in place like a will? I always say that a will and a trust pretty much work hand in hand together because some assets you may not want to put into a trust, like your car or your personal belongings or your everyday checking and savings account. Again, because you kind of have that payable on death form that will kind of take the place of that. So those assets are maybe left out of the trust, and sometimes people, and a lot of times people only will put their home into a trust because they want it to pass to their children. But what happens is if you don't have a will and you only have a trust, any items that have not been placed into the trust have to go through probate. So what we do is we do a pour over will, and our will lays out that pretty much at the time of your death, everything that you own, your personal representative or your trustee is instructed to now place everything into the trust, and now they can do the distributions. And that as well will also, again, avoid probate.
And remember, the trust isn't necessarily going to handle what you want or what wishes you have, and it's really more so focused with people that are with children, because the trust isn't going to give those instructions, who's going to be the representative, who's going to be the financial representative, or also, what is going to happen to you upon your passing. For you, it may be very important that you're cremated and your children feel very strongly against it. If you just had a trust, well then, and not a will, it'll protect your property, it'll protect your things, but it may not protect your wishes.
So if you had a last will filed in the state of Connecticut, you're saying that you have to now come and file it in the state of Florida?
No. So if you have a will done in Connecticut, if you pass, and let's just say you never do a Florida will, and you pass here in Florida, as long as the Connecticut will was executed with the same legal requirements that a will has to pass in Florida, it will still be honored, but it is going to follow under Florida rule. So if you've laid out a distribution that is not allowed under Florida law, even though Connecticut is from where your will is done, Florida rule is kind of going to govern there. But as long as it's executed the same way, and in Florida, for the execution for a will to be valid, it just has to be written. It has to be signed by the testator, and it also has to be witnessed and notarized, and all of that signing has to be done in the presence of each other. So as long as your personal representative, again, a Florida resident or a close family member, relative, then as long as there's really no other issues, then yes, it can still be valid. But sometimes, at least for us, we don't work on other states' wills.
And also, too, you have to understand that Florida is a non-reciprocity state. Florida is designed to kind of keep people and ideas out, in a sense that if you are a practicing lawyer in New York and you just want to skip down to Florida, it's not happening. So when it comes to things like how the laws are applied, it's more likely than not that it's probably going to conflict with that other state's law. And then again, now we're right back to the same place that we may want to avoid, and that's probate. And remember, you're going to now have Florida judges trying to interpret Connecticut law, and I can tell you from suing insurance companies for the last 20 years, it's a real hot mess when it comes to the actual litigation of it. And the whole purpose of all of this is to avoid anyone in the court system making a decision that should be solely yours.
Does Florida recognize holistic wills?
Holistic or holographic?
Holographic, they call them holistic up north, but.
I don't think so. Those are handwritten rules, right?
Right.
Yeah, I
Correct, yeah.
don't. No, I think ours have to be written.
I'll quadruple check, but
Yeah.
no, because we have had that issue.
Because you're not saying the right things between each other. So you have a list, holographic will, which is written, but you also have your state requirement, which is in the presence of 2 witnesses, and then you added the notary on top of that, all together at one time. So,
I mean, I think you kind of answered your question.
no, but in the case that's all there is a listed holographic will.
Then you're probably going to probate. If there's a conflict.
Correct.
Remember, probate doesn't just pop up out of nowhere. It's going to be, is there a conflict? But a judge may interpret it and say that that's not a valid will. And again, when you file your will in the state of Florida, the courts, their first step is to just determine, based on the 4 corners of it, is it valid? If it's valid and there's no conflict, it gets left alone, which probably is the overwhelming majority of those that are filed. It's when it becomes a conflict, and now if you have a holographic will, or as you said, a holistic will, and there's a conflict, it's going to give a judge a reason to say it's invalid.
So I just wanted, if there's a living will and a healthcare proxy and a ladybird deed and a payable upon death, then there would be no need for a durable power of attorney.
So a durable power of it depends. It depends.
On how?
Correct. So not everybody. So a durable power of attorney is something that you're going to need while you are alive. So that's something where, so let's just say you're traveling out of the country and there was fraud on your bank account and they need you to come in to sign new paperwork. If your daughter is listed as the power of attorney, she could go in while you're perfectly fine, no problem, no nothing, you're just not able to physically come to the bank and sign the paperwork. She could come in and sign on your behalf. So that's all it is.
While I'm alive.
While you are alive, correct, because the power of attorney does die at death. It is you cannot use a power of attorney after the principal has passed away.
So my friend here, what if she wanted to leave her assets to a non-family member? And that she sets everything up in a trust or whatever, and that non-family member passed away before she does? Then she has to quickly redo all of her documents, or what happens?
Yeah, so it kind of depends on how you set it up. So a lot of the times people will also list a secondary beneficiary to take. So let's just say, right, you've listed somebody and they've passed away. A lot of times what'll happen is that you can name somebody else. If this person is unable or unwilling to take, then the distribution is to go to X, Y, and Z. If you don't list anybody, they're going to go by Florida law, which will then, I believe, they'll look for heirs under the testator, not under the person that they've named. They have to go by the heirs of the testator if nobody else has been chosen as a secondary.
Can the second beneficiary be a charity, not a person?
Yes, absolutely. You can give and distribute your assets to whoever you please. You can give all of your assets to a charity.
You can set it up as a pet trust if you want.
Correct, to your pet. So it's correct. There's no, or you can leave out children. And again, now when it comes to spouses, I think as you had mentioned with the homestead, there are some, you can't leave out, like if you have a spouse and you are both living in the home, you can't just give that home to somebody else. Your spouse is the automatic right to get that home, or if there are minor children in the home as well, they will automatically get that home.
If you're living and you have a bank account.
With a copy of your death certificate.
With a copy of your death certificate, collect that money.
Yep.
Without any problem.
Correct.
So what happens when you go to the bank without, and you are the beneficiary, but the bank denies you?
Well, what'll happen is, so let's just say you're the beneficiary, but you weren't listed, like in the will, and it says that you get everything, but you were not listed on there as the payable on death or the beneficiary. You're gonna have to go through the court, for a judge to sign off on it, and as long as the will is fine and it was executed properly and there's nobody else challenging it, a judge is gonna look at it, say, great, he'll sign off on a piece of paper, they'll take that paper back to the bank. Again, they'll probably have to send it through to legal, they'll take some time, once they see that everything is good, then they'll be able to have access to
So a
it.
friend of mine died without a will, but they had money in the bank and a beneficiary on the account, but the beneficiary was not able to get the money.
That is something that we really have to kind of like look in specifically, but that's one of the big benefits of the beneficiary and the payable letter. In theory, they're the ones writing the legal documents because it's their own internal document, and it should be cleared before, you shouldn't just walk in, give the document, nobody looks at it. It should be cleared to avoid that exact situation. We'd have to kind of really delve into that a bit more to find out like what that specific reason. But as a whole, that is not something that we hear very often. There's something off about that.
How do medical providers know if you have a living will or a medical proxy?
Right, so whoever.
Sure. Typically, if you've all gone in for any type of procedure, whether it's something as simple as a colonoscopy, that's why on that form, almost all the entry paperwork that you sign, they always ask, do you have one? It's not necessary, unless you're very, very paranoid about it, to bring a copy to give to them, but that should be the trigger to say that they know about it. And it's also really important to communicate.
What about an ER room?
Well, that's gonna be something that hopefully a loved one is there and they know that they're named as the healthcare proxy. Believe it or not, so many times people will name a healthcare proxy and they don't bring it up in conversation to them.
Do they get recorded?
The healthcare proxies?
Yeah. Do
No.
they get recorded in the courts? No?
No, no,
And
no.
neither do living wills?
Nope, they're just documents that you keep in your own, like you said, it's
Do
just.
they have to be notarized?
The living will and the healthcare proxy, no, they do not have to be notarized. A power of attorney has to be notarized, but they do have to be witnessed.
Yes.
So you have to have two witnesses, but it doesn't have to be notarized.
That's why communication is really, really, really important when it comes to this stuff, because although you may be making all of these decisions, you really have to have the conversation with whoever you're gonna name as an executor or the person that's gonna have, the healthcare proxy. You really have to tell them so they know that they have to advocate on your behalf. And it's one of those things you may say in passing and they may not realize the gravity of it. They may forget about it. So it is an ongoing conversation. We always tell people communication is really, really important. You don't have to hand somebody a copy of your will, but they really do need to, if they're gonna be an executor, where it is.
So can you explain the legal realm of directives, like your health insurance? Mine has directives.
Oh, okay.
And in the directives, it asks you, what do you want to do, da 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 da.
Yes.
How legal is that? I mean, is that
Yeah.
binding with the courts and all of that?
Yes, absolutely. So it is all the same thing. So you can have healthcare directives, and that can include a living will. That can include the healthcare proxy or the medical power of attorney. It can
What
include.
you want at your death or what you want
Yep.
while you're ill or incapacitated or whatever.
Yeah. So they're exactly the same thing. It's just the terminology.
And it's
that's
in your
used.
own words, and it's legal, and does it have to be notarized, or is your,
The healthcare directives and the living will, they don't have to be notarized, but they should have two witnesses.
your healthcare directive?
Yeah, sometimes the confusion comes because they're essentially all of the same things, they just have different titles.
Yeah.
And that comes a lot of times from the legislature where states name them differently. So a common term for, a living will or healthcare directive in New York could be called one thing, holistic, holographic will could be called here, and, it's one of those things, that's why you really do need to educate yourself a lot about it.
You had indicated that the state of Florida doesn't really want to concern itself with other state languages.
Well, I don't know about concern themselves with it, but they're not keen on interpreting it. They're going to apply Florida law to that.
So you're a Florida resident, you're out of state, and you become deceased.
Okay?
So is that two probates, one in the state you died in and one in Florida? Or does Florida say you can die anywhere but
Correct, yes, no, for that instance, that specific thing that you're saying, yeah, just because you went to Vegas and had a really good time and didn't make it back, does not mean that Nevada law is going to go to, but that's a really good question.
Yeah. And I think we have a question.
So-
Oh, hold on, again, you got-
so there's 2 probates open or one?
No, one.
Just one around Florida?
Is, do you need to record or file the trust?
No, a trust does not get recorded at all, not when it's executed, not after your passing, which again, sometimes if privacy is one of your main concerns, that's why we would recommend a trust, because no, at no point in time.
I mean, for example, we had a call the other day, someone won the lottery.
Oh, yeah.
And they wanted to put it in a trust. They wanted to put it in a trust to be anonymous, and unfortunately, we had to give them some bad news that the lottery law says that they have to disclose their name. I think their name, their hometown,
Yeah.
and the winnings, but they can have the lottery winnings given to the trust. But they do have to say, like, Mary Kay won.
Yeah, something.
So yeah, she wasn't very happy about that, but nothing we can do about that.
So, all right, any other questions? Oh, yes.
Are you required by law on a trust to notify the people that are benefiting from the trust?
Beneficiaries?
Beneficiaries?
No, you have to
No.
follow the rules.
Correct. You have to follow the rules and so if you're named as a trustee, and let's just say as a trustee you're not a beneficiary, and you have to give. So let's just say you're the sister of the person who died, and you're to make sure that her beneficiaries are her children. What happens is if you don't give them their distributions, their proper distributions, you as a trustee are held to a legal standard, yes. So obviously if this is a conversation and they know that there should be the only 3 that are benefiting and they're not receiving anything, then yes, you at that point, then your trust may end up in probate because you're gonna have the court intervene because they are held to a legal standard to make sure that the distributions are to be given how they're laid out.
So the trustee has a fiduciary duty to follow the rules established in the trust, even if they're getting no benefit from it. So they can't just be like, well, I'm gonna give of $100, I'm gonna give $2 to the sister, but I'm gonna give myself $98 for being the trustee. That's not how it works. And if they do get sued, there's a clawback that those monies can be taken back.
Just to clarify, the trustee, are they required by law to notify the beneficiaries before the trust holder or the grantor is deceased?
Depending on what the trust says. Meaning if the trust has the instructions that you have to be notified, and I know what your question is, I'm gonna get there, but if the trust says that you have to notify upon death, then yeah, they have a legal obligation, they have to notify them. Most trusts aren't going to require that the trustee notify the beneficiaries before the passing. But if it's in there, yeah, they do. They can't withhold them.
And a lot of times your trustee will also potentially be a beneficiary. So a lot of times it is somebody that, if you have 3 adult children, you may name your oldest as the trustee. So then kind of everybody's in the loop there. But yes, a trustee can also be a beneficiary and so forth. So.
And one thing, again, I know I keep kind of on this side of the room, harping on communication. Just because you name someone as a trustee or an executor does not mean that they have to do it. They can turn it down. So you don't want to just assume that your sister is going to want to be the trustee and deal with your 6 kids, because she just might not. So it's always a good idea to have some conversation and say, are you willing to do this? And remember, a trustee or an executor can receive reasonable compensation depending on what parameters that you put on it.
If you put your house in trust, do you lose your homestead?
No.
No, you do not.
Okay, because somebody told me that they lost their homestead when they did.
Now you do have to file additional paperwork, yes. So if you just do the quick claim deed and put your home in a trust and you did not file the additional paperwork to keep that homestead on there, then correct, you absolutely.
It doesn't transfer from you as the individual to the trust. It is really like, what, a 2-page document that you're like,
document,
yeah, it's like,
okay.
hey, by the way, you know, here's this, I'm still involved in, this is going to be my homesteaded property.
Okay.
Good. Okay, well, if there's no other questions, thank you all so much for coming.
From previous experience, I know that sometimes at seminars like these, people may not necessarily be comfortable asking questions. We're happy to stay around, or if you guys want, we're happy to set up some times. I think Ms. Nicole has it here. Call, ask us your questions. If you leave and you're like, ugh, this question, call, email us. We're really here to help, and what we want to do is just to make sure that your wishes are carried forward and that we can kind of make sure that everything goes smoothly and you don't have to worry about anything in the future. Thank you again, Ms. Harris. Thank you so much. Thank you. Yes, take a plate, please, please.
Please come grab a cup as well here.